Hey everyone, Rob Ryder on December 25th, 2012. Something very interesting happened December 21st, 2012. As far as I can see, the world didn't end, but somebody's might have, because in the state of New Hampshire Judicial Branch Superior Court, in that case number against the Bank of America, you are hereby notified that on 12/20/12 has entered the following order: petition to enjoin foreclosure. Order made, a copy of which is enclosed herewith. What does that look like? It looks something like this. So, in that case number right there, final order on petitioner's request to enjoin foreclosure. On December 20th, 2012, a hearing on the petition to enjoin was calendared. The respondent, Bank of America, was served in hand December 13th, 2012. The pro se petitioner appeared. Respondent, Bank of America, did not. The respondent, Bank of America, is enjoined from proceeding with foreclosure proceedings. This is a final order subject to reconsideration by the respondent bank upon explaining why said respondent failed to appear and the assessment of a fine to cover costs associated with the petitioner's appearance. So ordered December 20th, 2012 by this presiding justice. Okay, so that's what happened. What do all these words mean? Let's go take a look. So what is enjoin? To require, command, positively direct. To require a person by writ or of injunction to perform or abstain or desist from some act. Easy enough. And they talked about cost. It's the sum of the equivalent expended. So this is a foreclosure. As far as I'm concerned, what's the sum? Well, everything that the petitioner had paid so far. Securities and their gains, conversions, gains, payments, and. Cost. It's a pecuniary allowance, which is monetary, related to money. Financial consists of money or that which can be valued in money. And he also talked about, did they not? Oh, and the assessment of a fine. Well, what's a fine? Oh, that's to impose a pecuniary punishment. And again, it's a monetary punishment to pay a penalty of money. A pecuniary punishment imposed by lawful tribunal upon person convicted of a crime or misdemeanor. A pecuniary penalty. It may include a forfeiture or penalty recoverable in a civil action, and in criminal convictions may be in addition to imprisonment. Oh. Well, they did commit fraud. A fine is so called because it puts an end not only to the suit thus commenced, but also to other suits and controversies concerning the same matter. They imposed a fine. And a fine is so called because it puts an end not only to the suit thus commenced, but also to all other suits and controversies concerning the same matter. Touchdown. And a penalty. Penalty's got a lot of definitions too. Anyways, those are their words. And why did I put penalty? Because here it said also see penalty under fine. Different shades of meanings. Involves idea of punishment, corporal, jail time, pecuniary, money, or civil or criminal. Though its meaning is generally confined to pecuniary punishments. So normally, generally confined to money punishment. The sum of money which the obligor of a bond undertakes to pay in the event of his admitting to perform or carry out terms imposed upon him by conditions of the bond. Yeah, somebody put in a court case. A penalty is the sum inserted in a contract, not as measure of compensation for its breach, but rather a punishment for default or by way of securing for actual damages which might be sustained by reason of non-performance. Didn't perform the contract. And so all this is based on, about 3 videos ago I did one called Possible Petition for Court of Chancery, which John in New Hampshire put in for his friend Elaine into a court case, and they had a hearing on the 20th, and nobody showed up for the defense, which would be the bank or their attorneys. What we didn't know at the time is really how to close the deal, and what we should have said, well, based on the preponderance of the evidence, we're asking for summary judgment. And we'll get into that more here in a minute, because, as you think about these things, you sometimes write it different the second time. So I'm not saying I know the right way to write it, but I know what happened with this. As bad as it was, it got an enjoyment on a foreclosure. Now, doing an enjoyment is opening up your own case, basically, referencing the other case, and that is one way to do it. But looking a little closer in the civil procedures, right? So every state's going to have some rules on civil procedures. Go find yours, right? That'd be the first thing to do. Go find your civil procedures and understand what it takes to put in a pleading, whether it's an answer to something or counterclaim or answer counterclaim, or if you're putting a complaint in. All these things are different kinds of proceedings or pleadings, but they all look the same apparently when you put them in. And we just want to be sure we're putting it in the right court, and we don't want to put it into a court of law. We want to put it into a court of equity. And when you walk into those courtrooms, those are courts of law. Well, we don't want law, we want equity, because in law, because they have the piece of paper, the law says they're the owner. You got a piece of paper with your signature on it, only yours. It's a unilateral contract, but law will enforce it. Equity will say, he didn't mean it to be a gift. You're not going to sign the contract. Give him back his property. Okay, I can close that one. So, some of those civil procedures, we're going to use this as an example here, right? This is Rose's friend in Cook County, who's being foreclosed on. And so Roe went to the Chancery side to get the records for the court case. And this was what was in there. Right? This is their, this is like a new case cover page. Right? And then this is the complaint. And this part up here is called the caption. And so every pleading, no matter what kind you put in, it says you need to put it in the form of a caption. So, right, if you were going to answer this petition, the court you would be sending it to is in the Circuit Court of Cook County, Illinois, County Department - Chancery Division. And that's where you would be answering this complaint. A complaint was sent to you, and you need to answer it. If you never answered it, well, then you need to. Because in this case, on this complaint, which ends there, there's no signature. And we'll find out that's very important. Nor was it put under oath. So this is the complaint, again, and this was put in on August 22nd. And then these next pages are in February 15th, right? So this is the same attorney firm. Now they're putting in something else. Now they're going to put it in an order, right? They wrote the caption. They wrote the order. All that happened is the judge signed it. But they didn't sign it. Again, it's not signed, has no value. But I'm showing you what they put in, right? So they're writing their own. They're writing an order of default, an order of summary judgment, If you want to read these, just stop it and read it. I'm going to continue on because this isn't really what I want to talk about. Again, not signed by the attorneys. Apparently, that really isn't a signature. Is this... Okay, let's see. Would we call that a signature? Yeah, I guess we get away with that. But see how this says Kenneth C. Brown, presiding justice underneath it? This just says judge, right? That ain't good enough. Judge ain't a signature line. That's a signature line. That's lawful. Got the guy's name in his office. Right? I don't know that this counts here, this Judge Alfred M. Swanson with a frickin', with a court stamp, and then somebody scribbling his initials on it, right? I don't think it's proper. I think it has to be this way. So we're going to be doing orders, so what we would do is look to see who the judge was on our court case. All right, so order. Again, this is the plaintiff, basically the attorneys for the plaintiff, writing the orders. And all that's happening is the judge is sealing them. So they want us to move the court. We need to have a hearing, have a pleading, put it in, and then notice of motion for summary judgment. And that's what's next for John in New Hampshire. He's pretty much got it locked in what he's going to go do. Sounds good to me. We'll see what happens. And then judgment for foreclosure and sale. So really this is the judgment for foreclosure, right? That's what they're asking for first. And then all these are put on the same day, and then these orders would have been part of the hearing, or part of it also. Okay? So, like I said, if you go to possible petition for court of equity, a video I did about 3 videos earlier than this, you'll see the one that we used. And now I'm going to show you that I've changed a little bit, because that was really written to go in and open a case, even if you weren't in foreclosure. And so now we're going to tailor, okay, I'm in foreclosure. I know a case has been open. If I go to the civil side of the court, right, I should be able to find this, which is a new case cover sheet and the complaint, and I will have evidence that it was never signed. Let the record show it's not been signed. Also, you're supposed to get a summons, and in Michigan, so this is out of Michigan's, right? And this is if you're doing a civil proceeding. A summons must be issued in the name of the people of the state of Michigan. Well, first of all, there was no summons at all in this. There is no summons that I can see, so the guy was never properly summoned to court. That's not good. And so if it appears reasonable, because this is about cost, right? If it appears reasonable and proper, the court may order the opposing party to file with the court clerk a bond with surety as required by the court in the amount sufficient to cover all costs and other recoverable expenses that may be awarded by the trial court. We're going to see what the trial court's going to give John. Designation of a cross-claim counterclaim. A cross-claim counterclaim may be combined with the answer. A counterclaim or cross-claim must be clearly designated as such. So if somebody makes you a respondent in a civil matter, which is where they start these foreclosure cases, they're started in, can't make any plainer, man. This is in Chancery. Chancery Division. Where they call it Chancery Equity, whether you just ask them, well, when an attorney starts a case, where does he put it in? Wherever that is, go get your court case and say you want the frickin' records. Go to the civil side. But because they've opened this and you were supposed to answer, you need to put in a responsive pleading. And a responsive pleading is an answer. And this is saying, and part of that answer, you can put in a counterclaim. A responsive pleading is not required to cross-claim or counterclaim that is not clearly designated as such in the answer. Okay? So they don't, so when you put one in, now they have to answer. But it's not required unless you designate it as such in the answer to be in a cross-claim or counterclaim. All right? So you can read these other parts, but you know your state may be a little different. So really, go look at your civil procedures and just see how you put in a counterclaim, right? And you know, start there. A statement of a claim, complaint. The complaint must contain the following statement of facts without repetition on which the pleader relies, stating the cause of action, which specific allegations necessary for reasonably to inform the adverse party of the nature of the claims the adverse party is called to defend. Show them the evidence. A demand for judgment for relief that the pleader seeks. So they also want you not only to state the facts, but what is it you're demanding? A demand for judgment for the relief the pleader seeks. Declaratory relief may be claimed in case of actual controversy. Apparently there's one. You're in court. Relief in the alternative or relief of several different types may be demanded. You want specific performance on the warranty deed to make it a lawfully recorded purchase agreement between you and the grantor, who conveyed to you good title to the land, which goes all the way back to the land patent. You want the title deed, it's never been given to you. And furthermore, the bank has never signed the deed of trust or mortgage, which is a security agreement. Go read just above where you sign your name. It says it's a security agreement, and there is no signature of the bank on there, and therefore it's a unexecuted bilateral contract. They're going to say it's a unilateral gift if you go to law, and since they got the piece of paper, you're screwed. So you need to tell them, I didn't mean it to be a gift. Form of responsive pleading. So this is an answer of some kind, right? As to each allegation for which adverse party relies, responsive pleading must state the explicit admission or denial, right? So state an explicit admission or denial. State that the pleader lacks knowledge, right? You can say that they didn't give enough information. Defenses, requirement that defenses be pleaded. All right, so you can use a equitable defense to a complaint brought in equity, and this was most certainly brought in equity because it was the Court of Chancery. They came with unclean hands, right? They came as a false accuser. They didn't sign nothing. You can plead special matters such as fraud, mistake, condition of mind, malice, intent, knowledge, other conditions of mind may alleged generally, right? And as you can see, that a fine could be imprisonment. They could be going back to the fleet, 30 days in the brig, back to the fleet, according to Lord Coke. We'll find out soon. Denial of performance. So these are the special matters that you can plead as part of your answer. You can also pick law of other jurisdiction, because we really don't know what law they're using. So what I'm going to tell them is I'm using the maxims of equity. I could tell them I want to use canon law 1983 and claim canon 204, where I claim the priestly, prophetic, and kingly office of Christ. I could pick the Northwest Ordinance. Whatever form of law you want to use, you just need to tell them, must give notice at intention, whether it is either in his pleading or her pleadings, or in a written notice served by the close of discovery. Okay, forms of pleadings, right? And then this just kind of tells you how you need to do it. They want it here in Michigan, 12-point. They want captions. This is what the caption must state. And then if it's a caption of a complaint, right? And again, right? Oops. This here is the caption. This crap up here. Right? This up here. So you want to make sure when you're looking at when you go get the original charging documents cover sheet, it's going to have the name of a court on it. Whatever this court is the court you want to take it back to. My opinion. Right? Because I bet you that's not the same as the name of the court where the guy went to have a foreclosure hearing. Probably like 16th Judicial Court or something like that. Right, so answer back into the Court of Equity. That's where they brought their complaint into. That's where you should put your answer back into. Names of the parties, yada, 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 right? Signatures of attorneys and parties. Well, one of the things is, I declare that statements above are true to the best of my information, knowledge, and belief. Should put that. That'd be your verification. And then signature. Failure to sign. If a document is not signed, it shall be stricken unless it is signed promptly after omission is called to the attention of the party. Right? There ain't a fucking piece of paper, excuse my French, except this first page. And I don't know if you can call that a signature or not, but okay, let's say it is. None of these, the complaint don't have a signature. Orders don't have a signature. None of these other pieces of paper have a signature on them. Right? So they're the ones that submitted it. They didn't put their signature on it. Sanctions for frivolous claims or defenses. In addition to sanctions under the rule, a party pleading frivolous claim or defense is subject to cost as provided, and boom, there's where the costs come in. It's a frivolous claim. They don't have no frickin' claim to your property. They didn't sign any paperwork. The bank didn't sign the contract. A motion for a more definitive statement. If a pleading is so vague or ambiguous that it fails to comply with the requirements of these rules, an opposing party may move for a more definitive statement before filing a responsive pleading. Summary dispositions. Anyways, so this is kind of what I've come up with, and when I send this out, it's just going to be attached to this. It's at the bottom. These are ideas. You can use them how you want. But we'll just go through it. One of the things is it wants you to number all your paragraphs. Okay, so where it says caption page, right? You got to start out with whatever this is going to be up here, right at the top of your paper, and then they like 1.5 to 2, 1.5 space to 2 space, something like that. And that is not how this is written. But the title on the caption page: responsive answer to complaint invoking equitable defenses, counterclaim by motion for summary judgment, and just remedy based on the preponderance of the evidence. Right, so that's going to go where this says order to appoint selling officer. That's where this goes. That's your title. First paragraph: responsive answer to complaint. A plaintiff of, put the case number, get rid of the red, put the case number down. (11CH). I'd go up to the top, though. What was the original one that was put in? Right there, 11CH. Excuse me, you put that in. Comes to equity. Now, it could be plaintiffs or S, one or more, I don't know. Comes to equity with unclean hands. Plaintiff's complaint is not under oath, nor even signed by the plaintiff, and I am not bound to answer false accusers. I demand plaintiff testify the validity of their claim under oath or be found in contempt of court, because they brought a frivolous filing. Number 2, plaintiff's complaint is far too vague for a reasonable man to determine what evidence is the basis of their complaint, and as owner of the property in dispute, I lack knowledge and information sufficient to form a belief as to the truth. Of the allegation, it should be truth of the allegation. I demand to know by what authority the plaintiff filed this complaint and their attested evidence entered into the record. All right, so that's my answer to them. Now here's my motion. Counterclaim for summary judgment and order for swift justice and just remedy based on the maxims of equity and the preponderance of self-authenticating foolproof evidence in the form of public record. Counterclaim by the owner of, right? So this is your all capital letter estate, because that's what they're charging. What are they charging here? This dude here. On that page. And then On the complaint, they have him listed. Right? That's your all capital letter name estate. It's your property. Claim it. Get rid of the blue, all caps, comma, estate. Now comes the owner of whose real full name is, and that's your last name, comma, space, first middle, for equitable relief and just remedy in the matter of unjust claims of plaintiffs and others unknown to me concerning ownership rights, title, and interest to certain real and personal properties of this owner. It's my property. Equity will not suffer wrong without a remedy. Owner believes plaintiffs or their agents learned the law, officers of corporations bound by solemn oath may have acted in bad faith. A color law process and unexecuted contracts are being used against this owner to disseize him or her, whichever you are, of his or her property under the name of a fictitious plaintiff, which could be construed as fraud. Equity will not permit a statute to be used as an instrument of fraud. The owner believes certain instruments have not been lawfully executed in accordance with the laws of the land as part of the scheme to control the rights, title, and interest of the owner's land, real property, real and personal property described in the instruments titled. Now, if they call it a warranty deed, whatever they call it where you're at, sales deed, warranty deed, the thing between you and the grantor, deposit in the office of, what do you guys call it, county clerk, register of deeds, whatever it is, in the county of, wherever you are, book page, file number, whatever it is, the date that it was done, as well as the deed of trust, could be called a mortgage, could be called a security deed, right? Same stuff. Identify what it is. Because you're doing this in the county where these are recorded, you don't even need to attach them. However, we're going to give them some information. These instruments are self-authenticating, foolproof evidence already recorded in this county. Extracts of the warranty deed, Exhibit A, and deed of trust, Exhibit B, evidencing properties in dispute, and signatures of parties of interest have been included to facilitate this court's decision. Equity regards as done that which ought to be done. Third parties involved as agents have not executed their fiduciary duties as part of the closing of a bona fide purchase contract known as warranty deed to ensure it was properly recorded, transferring good title into the hands of the owner, resulting in a form of joint tenancy between the owner and third parties of unknown identity. Somebody else has a title deed in their hand, and that's the legal title. You have equitable title because you have possession. You want the legal title so you can have absolute title. Call it fee simple, call it whatever you want, right? Absolute title. You want both the legal and you want the equitable. And they didn't complete the contract because it didn't tell you to acknowledge the warranty deed between you and the grantor to say, I accept it. And then it needed to be lawfully recorded in the county recorder, lowercase register of deeds, someplace other than where you're going to get the copy out of, because that's the fiction side. We want it to go to the office of the recorder, chancery, whatever they call it where you're at. That's where, because it's the office of the recorder that determines what the law is. The law is based on the records in the office of the recorder. I don't know that they're going to call it that in your state, but the chancery is where true public records, the records of the people, are kept. And the recorder is usually the chief judge of a district. Okay? As grantee on the warranty deed previously referenced, I accept and acknowledge grantor's desire to convey this owner good title back to the original land patent, which was to be evidenced by the title deed being delivered into my hand. Owner requests the discretion of this competent tribunal in a court of equity by court order to compel the immediate specific performance and lawful execution of the purchase contract known as warranty deed and the good title deed to the lands as well as rents collected for the owner as tax being placed in this owner's hands, right? Because the tax that you've been paying is a rent due to the owner. It's just the owner had never appeared. Somebody was doing you a favor collecting rent. It's yours. Ask for it back. You're the owner. Equity will not assist a volunteer. The warranty deed indicates that the grantor granted and conveyed, grant is a gift by the way, and conveyed the land and real property described on its face and said grantor's recorded acknowledgment of receiving good and valuable consideration in satisfaction of the purchase contract is evidenced by the included warranty deed. He recorded it, right? He signed it. It was recorded, been sitting in the register of deeds ever since. The owner was compelled, excuse me, by the deceit of those learned the law that a loan was required between this owner and a lender evidenced on the included deed of trust as part of the land purchased by warranty deed, upon which the lender claims to be loaning this owner the lender's money. Owner is led to believe that no recorded bona fide lien or for a loan of money nor any other consideration given by a lender. They didn't do anything. The said deed of trust has not been acknowledged by the lender or trustee of record, resulting in an unexecuted bilateral agreement with which the lender or successors now claims an equitable mortgage over the real and personal property of owner's landed estate. Again, your all caps. Get rid of the blue. It was not the owner's intention for this to be a gift or an unexecuted use held in trust under control of a lender as a binding unilateral contract. And I've talked about what all that means in prior videos. Therefore, I revoke the deed of trust and ask for injunctive relief by court order to have my securities, their conversion, and game returned to the use of the owner. I want my property back. He who seeks equity must do equity. Owner wishes to ensure equity is given to and by all parties of interest openly admits not being learned in fictional forms of law. Owner fully comprehends and stands under the laws of his Redeemer, the Lord Jesus Christ. Asks that if necessary to ensure transaction made in good faith is properly executed, counsel learned the law be appointed to represent the owner. I don't think I should say represent, because he's not really representing you. He's your counsel. C-O-U. As other instruments of indebtedness appear to be claimed against the land, real and personal property of this owner, there is possibility these instruments have been done in bad faith. Owner asks that all records, books, and accounts with full accounting as they apply to the owner's landed estate be subpoenaed as evidence to determine and establish the owner's rights, title, and interest therein. Now, I hope you all understand these last couple here have really nothing to do with the frickin' house, right? This is going after your body, which is also land that's been recorded, registered, and your landed estate, and the legal titles are in somebody else's hand, and that's why they think you're their property. And yes, they exist. They think you're their property. That's all you are, is a piece of meat. So if you can stand in these last two paragraphs here and say, hey, I want everything from my estate. I want a counsel learned in the law be appointed to counsel the owner to make sure you get everything in your estate. I don't know that they'll do it as part of this, right? But I freaking ask for it. All I can do is say no. Owner, believing it is his duty to the King of Kings to point out transgressions of his law, has brought this counterclaim into the court of equity. As the court has now been made aware, I leave it in the hands of a competent tribunal, the keeper of his conscience, to see that swift justice is done in his name. I declare under the penalties of perjury that this petition has been examined by me and that its contents are true to the best of my information, knowledge, and belief. Date, sign it, put your last name, first, middle, address, city, state, zip, telephone number. And then do another caption page for an order. Order for summary judgment, swift justice and just remedy. This counterclaim coming to be heard on owner of your all caps estate. Motion for summary judgment, swift justice and just remedy against plaintiff's attempts to use color law process and unclean hands to enforce an imperfect gift. And the court, finding no material issue of fact has been raised, it is hereby ordered that summary judgment in favor of the owner be granted, and the title deed, securities, their conversion and gain, as well as rents collected for the owner, be placed in the hands of the owner of that right there, all caps estate. Further, it is ordered that a special master, expert in real estate law, shall be appointed to the owner whose real full real name is your last, first, middle, of your estate, to ensure said owner receives full and complete relief in equity by way of natural justice to establish for the record the owner's superior rights, title, and interest to all his property and protection of his God-given rights. And then you had to put, something for the judge to do. But probably more like this one. Right? So ordered. This is how the court did it. They put the date and a line. Right? So the court did this one themselves. So the court must be happy with this. This is what it'll look like. This is an order. She was the plaintiff versus Bank of America. Well, Bank of America is going to get a fine. Ooh. Now, if Bank of America doesn't come and take care of this openly, and they rule against them, well, there's no reason you can't then go with the information in the form of quo warranto, demanding that the bank be taken over because they violated their charter. They didn't operate in good faith. Powerful tool, that quo warranto. But this is where it starts. So this happened on, they put it in on the 13th, and 7 days later, they got an order. And all we didn't do at the time was, when the bank didn't show, no attorney showed. Right? We think about if that had been us, what would have been the words out of their attorney's mouth? That he was motioning for a summary judgment based on the fact that the respondent didn't show. And so, I'm just trying to cover all the reasons why. I don't even know if this is the way it should look, right? But it's my idea of something you could use. And then again, this is this is completely another page. This is the order page, so you would do the caption pretty much like the other one. And we'll see what happens, because I've had 5 or 6 people now already email me, ask me to send them what I had done before and stuff. Go back and watch other videos. It's not that long. Write it down, right? This is really for people who are in foreclosure now. I think you can just go answer into the original case. You don't need to go open up a separate case. So who wants to go find out? Go give it a shot. Let me know what happens. Okay, y'all have a great rest of the week. We'll see what happens next.